My name is Muad Pasanda Mikawas. To explain about the war crimes. So, as for the introduction, war crime is a serious violation of the law and custom applicable in the armed conflicts and also known as an international humanitarian law, giving rise to the individual criminal responsibility under international law. According to some scholars, war crimes refer to a great breach of Geneva Convention or Additional Protocol 1, or a serious violation of the law and custom that allow the armed conflicts. This can include vehicle killing, torture or inhuman treatment, taking hostage, killing prisoners, attack on the undefended towns which are non-military objective, or attacks on civilians or those who are providing humanitarian assistance. The list is long, but the overall aim is international humanitarian law is to reduce unnecessary suffering associated with the conflicts. The formal concept of war crimes emerged from the codification of the customary international law that apply to the warfare between sovereign states, such as the Labor Code 1863 of the Union Army and the American Civil Law and the Hague Convention of 1899 and the 1907 for international law. In the aftermath of the Second World War, the war crime trial of the leaders of the Axis power established the Nuremberg principles of the law, such as that international criminal law defines what is a war crime. In 1949, the Geneva Convention legally defined new war crimes and established that states could exercise universal jurisdiction over war criminals. In the late 20th century, in the early 21st century, International Court extrapolated and defined additional categories of war crimes applicable to the civil war. Non-armed violation of international humanitarian law constitute war crimes. To be considered as a war crimes, the violation must entail, under customary or treaty law, the individual criminal responsibility of the person breaching the rules. War crimes are serious violations of international humanitarian law committed in international and non-international armed conflicts that give rise to individual criminal responsibility. Various provisions under international humanitarian law, customary law, and treaty law prohibit the commission of war crimes, grave breaches of Geneva Convention, and of Additional Protocol 1, 81 that apply in international armed conflict. Common Article 3 of the Geneva Convention that apply in all conflicts, and other serious violation of international humanitarian law that apply in either international or internal armed conflicts. Grave breach of the Geneva Conventions. Each of the 4 Geneva Conventions include grave breaches, provisions that expressly criminalize the most serious grave violation of the rules provided in the conventions. Grave breaches provisions discharge the act that amount to violation of the law of war as follows. A. Willful killing. B. Torture or inhuman treatment, including biological experiments. C. Willfully causing great suffering or serious injury to body or health. D. Excessive destruction and appropriation of property not justified by military necessity and carried out unlawfully and wantonly. E. Compelling a prisoners of war or a civilians to serve in the force of a hostile power. F. Willfully deprive a prisoners of war or a civilian of the right of fair and regular trial. G. Unlawful deportation or transfers or unlawful confinement of a civilian. H. Taking civilians as hostage. Next, in the Geneva Conventions. The first 3 conventions have been revised and expanded with the fourth one added in 1949. The first Geneva Convention for the amelioration of the condition of the wounded and the sick in armed force in the field was adopted in 1864, and then it significantly revised and replaced by the 1906 version, the 1929 version, and later the first Geneva Convention of 1949. The Second Geneva Convention for the amelioration of the condition of wounded, sick, and shipwrecked members of armed forces at the sea was adopted in 1906 and then significantly revised and replaced by the Second Geneva Convention of 1949. The Third Geneva Convention, relative to the treatment of prisoners of war, was adopted in 1929 and then significantly revised and replaced by the Third Geneva Conventions, 1949. The Fourth Geneva Convention, relative to the protection of civilian persons in time of war, first adopted in 1959 based on parts of the 1907 Hague Convention 4. The list of the grave breaches in the Geneva Convention was expanded in additional protocol 1. Grave breaches provision are regarded as part of customary international law. Grave breaches provision only apply to the violations committed during an international armed conflict and against persons who are protected by the Geneva Conventions. Protected persons under the Geneva Convention include civilians and combatants. Protected civilians, persons who are in the hands of the adversary. Protected combatants means a person who qualify as a prisoner of war. Common Article 3 of the Geneva Convention. Article 3 of the Fourth Geneva Convention, on the other hand, outline core rights that only apply in the event of an armed conflict that is not of an international character. In the third case, the ICTY ruled that Common Article 3 established a basic set of requirements that must be followed in all armed conflicts, whether they have an international or domestic character. It also can be seen in the case of the concerning military and paramilitary activities in and against Nicaragua. The conflict's nature is therefore unimportant. The ICTY further declared that criminal liability results from the violation of the Common Article 3 restrictions. The ICTR and the ICC statute specifically criminalize Common Article 3 violations. Other grave international humanitarian law violations that are punishable by law also provided under customary international law and other treaties. They outline restrictions that are valid only during international armed conflicts, only during internal armed conflict, or both during internal and external armed conflicts. Next, we move on to the Article 8 of Rome Statute. The ICC, under Article 8 of Rome Statute, has jurisdiction over the war crimes, including 1. Grave breaches of the Geneva Conventions, 2. Serious violation of the laws and the customs of international armed conflicts, 3. Serious violation of Common Article 3 committed in a non-international armed conflict, and 4. Serious violations of the laws and customs of non-international armed conflicts. It is significant that the Rome Statute maintains a clear distinction between those war crimes that are prohibited in the international armed conflict and those applicable in internal armed conflict. So this is the examples of the war crimes. There's the pictures of the armies, and this is the victims of the war crimes. This picture. So next we move on to the elements, comments on war crimes. The elements listed and described below are common requirements for all war crimes. These elements, there are 7 elements. First, armed conflict. There must have been an armed conflict when and where the alleged crimes were committed. 2, protected person. Means that the victim must be protected under international humanitarian law. 3, nexus, which means that there must be a sufficient nexus between the accused act and the armed conflicts. Nexus in this, we can understand that nexus like a link something. 4, existing international humanitarian law, which is the violation must be breach of customary or treaty international humanitarian law binding on the accused. 5, gravity means that the violation must be serious and involve grave consequences for the victim. 6, individual criminal responsibility means that the violation must be entail individual criminal responsibility of person breaching the rules. 7, awareness. It is also necessary to prove that the accused was aware that an armed conflict existed. So that all these elements distinguish war crimes from the ordinary crimes. Importantly, it is not just required to prove that war crimes were committed as a part of a planned policy or large-scale commission of such crime. So as I've been saying before about armed conflict, so basically armed conflict is the fundamental requirement of the war crimes is that crime occurred during an armed conflict. For the prosecution of the crime, it must be shown that the conflict was of either international or non-international character. An international armed conflict defined as a resort to arms force between the states, and a non-international conflict means that protracted arms violence between the governmental authorities and organized arms groups or between non-governments armed groups within the states. An armed conflict can become a mixed conflict, which is both international or non-international in character if first another state intervenes with troop. So some of the participants in an international conflict act on behalf of another state. So basically, international armed conflicts is armed force between the state, and then non-international armed conflict is between governmental authorities or even not between the non-government armed group, but it's still within the states. Both international and non-international armed conflict, it is not just necessary that two groups both apply force. Armed conflict includes invasions that meet no resistance, aerial bombing, or an unauthorized border posing by armed force. The states of armed conflict continue until a general conclusion of peace is reached, or in the case of international armed conflict, until the peaceful settlement is achieved. The state of armed conflict may also end by a decisive close of military operation without an agreement. So next, we move on to the test for internal armed conflict. For internal, which means that not international armed conflict, situation involving internal disturbance and sanctions, such as riots, isolated or sporadic act of violence, or an unrest, do not amount to armed conflict. The internal disturbance must reach to the level of the protracted armed violence. For the international criminal law to apply. According to the case of the Akayasu and the Fatmili March, the relevant consideration for determining whether the armed violence amounts to an armed conflict include first, the protracted nature of the armed violence, two, its intensity, three, the extent of organization of the parties involved. The above elements have been interpreted to look protracted nature means that the hostilities must be extended over time or include events that occur because of the conflict. This is analyzed by looking at the entire period of the conflicts, from its initiation to cessations. It's referred to the Thomas Lubanga dialogue case. Intensity means that the relevant factors to assess the intensity of armed violence, as elucidated in the cases of the Ramush Haradinaj, Slobodan, include first, number, duration, intensity of individual confrontations, two, type of weapons and other military equipment used, or number and caliber of munitions fired, three, number of persons and type of force partaking in the fighting, four, number of casualties, five, extent of material destructions, and six, number of civilians fleeing the combat zones. That's for international armed conflict. An armed conflict is an international if it takes place between two or more states. However, an internal armed conflict may become international if, like I said before, if another state intervenes in conflict with troops or some participants in the internal conflict on behalf of another state. There are three tests have been established by the ICTY in the TEDIC case for determining whether in conflict, which is prima facie internal, armed force may be regarded as acting on behalf of another state, rendering the conflict international. These tests differ depending on the nature of the entity being considered. So for the first test, it is test of overall control. It is applied to the armed force, militias or paramilitary unit acting as an organ of a state. In these cases, the establishment of overall character of the control suffices. The requisite control exists when the state has a role in the organizing, coordinating, or planning the military actions of the military groups, in addition to financing, training, and equipping or providing operational support to that group. The second test is the test of de facto state brigades. It applies to the single private individuals or a group which is not a military organized. In order to determine whether the individuals or the group has act as a de facto state organ when performing a specific act, it is necessary to ascertain that a specific instruction concerning the commission of that particular act had been issued by the state to the individual or groups. Alternatively, it must be established that an unlawful act had been publicly endorsed or approved ex post facto by the states. So for the last test, it's a test of individuals acting in collusion with state authorities. This test applies to private individuals who are assimilated to the state organ on account on their actual behavior within the structure of a state, regardless of the existence of the state institutions. In order to demonstrate that they are acts on behalf of another state, it must be proved that they are acts within the framework of or in connection with armed force or in collusion with the state authorities. The issue here is not the degree of the control, but the state controlled by the state, but the behavior of the individuals. Uh, So, lastly, we look at the list of the war crimes in the statutes of this tribunal and the ICC. The ICTY statute lists strict breach on the Geneva Convention, Article 2, and other violation of the law and custom war, drawing on other customary law sources, Article 3. The ICTR statute lists only serious violation of Common Article 3 and Additional Protocol 1, Article 4, and the ICC statute, which is the most elaborate, provide for lists 1. Grave breach of the Geneva Convention, Article 8, Paragraph 2, Clause A. Other serious violation of the laws and custom applicable in an international armed conflict, Article 8, Paragraph 2, Clause B. 3. Serious violation of Common Article 3, Article 8, Paragraph 2, Clause C, and the other serious violation of the laws and custom applicable in non-international armed conflict, Article 8, Paragraph 2, Clause E. The other serious violation listed in the Article 8, Paragraph 2, B and E are drawn from various sources that were accepted as customary law, including provision from Geneva law, Hague law, and other sources. That's all from me. Thank you.